Hello, everyone. My name is Ivana Isailovic. I'm assistant professor of law at the University of Amsterdam and the academic coordinator of the Sustainable Global Economic Law Project from now on, SGEL. I am truly thrilled to welcome you to the first book launch organized by SGEL, Locating Nature, Making and Unmaking International Law, an important and wonderful collection edited by two of the leading thinkers in this space, Usha Natarajan and Julia Dehm. Let me briefly introduce them. Usha is currently Edward Said Fellow at Columbia University. She has written extensively about international law and international environmental law from interdisciplinary perspectives, drawing on post-colonial and third world approaches. She's also one of the founding editor of the TWAIL Review, Third World Approaches to International Law Review, one of the most critical and vibrant spaces that exist. Julia Dehm is senior lecturer at LaTrobe University in Australia. She writes about domestic and international climate change, natural resource governance, human rights, and economic inequalities. And before I introduce other wonderful speakers who accepted to join us and comment on this book and be in conversation with Usha and Julia, let me tell you a bit about why it was important for us at SGEL to organize a conversation around this important book and Usha and Julia's work. So I don't think that there is a need here to remind you of the sobering facts. We are facing environmental breakdown. We are in the midst of the sixth mass extinction. The Earth is warming. Oceans are acidifying. Many in the global north are finally starting to wake up to the emergency and feel some of the effects of climate change, when that has been the reality for many underprivileged communities, especially in the global south, for many years. And in fact, the most vulnerable communities bear the brunt of environmental degradation, while the richest states are contributing to it. Within this context, the edited volume asks a series of bold and urgent questions. What is the relationship between international law and the natural world? How does international law construct, shape, and govern nature? How does it instigate further environmental degradation and entrench inequities and disparities? And what are the alternative ways of thinking? These questions are very much in line with some of the conversations that we've been having at SGEL. SGEL is a unique research project gathering lawyers from various disciplines, international, private, public, and EU law, exploring the interplay between global economic law, social and ecological injustice. And at SGEL, we have already greatly benefited from Usha and Julia's extremely generous engagement with our community, from the SGEL Summer School to the SGEL flagship conference from last December and the related symposium. So thank you, Usha. Thank you, Julia. I'd now like to introduce our speakers and thank them for taking the time to engage deeply with this work. Saptarishi Bandopadhyay is an associate professor at Osgood Law School in Canada, where he works on the history of international law, environmental degradation, and disasters. His recent book is entitled All Is Well: Catastrophe and the Making of the Normal State, and looks at the enduring history of global disaster management. Devanshi Saxena is a PhD researcher at the University of Antwerp, where she works on the law of intellectual property and sustainable development. Finally, Ingo Venzke, professor of international law and social justice, and this year the managing director of research of SCEL. Among other things, his work focuses on the theory and practice of interpretation in international law and the role of international law in creating global social injustices. So here is the format of the event. We will first hear from Julia, who will briefly introduce the book. Then each commentator will make brief comments to start the conversation with Usha and the audience. After that, we'll have some time for conversation among the panelists, after which I will open the floor for your questions. Julia and Usha, the floor is yours. And again, thank you so much for being here with us.
Thank you. Thank you, Ivana, for hosting this book launch, and to Ivana and Ingo and Saptarishi and Devanshi for kindly sharing their thoughts. It's really so much appreciated, particularly because, as Ivana described, the Sustainable Global Economic Law, SGEL, at the University of Amsterdam School of Law is the perfect setting to talk about the reasons why we did this project. So the initial idea germinated about a decade ago when, for me, with the onset of the Arab uprisings, and I've lived in the Middle East for the last 13 years, and there the links between the natural environment and systems of law are very evident on a daily basis, perhaps most obviously in terms of access to natural resources and benefits from them. So my concern was that those explicitly focused on the environment in international law, so international environmental lawyers, my concern there was that, you know, international environmental law obviously wasn't working, that all the environmental issues that we wanted to address were steadily deteriorating. So that was my concern about what was happening with international environmental law. And then at the same time, most other international lawyers were not particularly interested in the environment, either because it seemed too sort of specialized and esoteric and maybe a little bit scary, or because perhaps it just seemed irrelevant to their concerns and not particularly interesting, maybe a bit boring for that reason, you know. So the Edward collection is trying to speak to both these groups, to say to international environmental lawyers, perhaps one of the reasons why our efforts haven't succeeded is because we have created a specialization that allows international environmental lawyers to tinker at the margins of a discipline without engaging with how environmental destruction is very much at the heart of the international law project. And then to speak to generalist international lawyers and those in other specializations to say to them, well, here is how understandings of nature are central to shaping our discipline, to shaping all its concepts, from sovereignty to development, human rights to labor, territory to jurisdiction, and so on. So with this aim in mind, I really do appreciate the wonderful group of commentators here with Ivana, Ingo, Saptarishi, and Devanshi, because their expertise ranges from transnational and private law to legal theory and generalist principles, disasters, displacement, trade, finance, intellectual property, human rights. So, and all of their work is committed in diverse ways with engaging deeply with environmental concerns in these different areas. So they're just perfect in terms of assessing whether we've been able to speak effectively to our target audience and, you know, what more work needs to be done in this regard. So when we started out, there weren't a lot of people doing this kind of work in international law. So my partner Kishan Kode and we turned first to Karen Mikkelsen and Ileana Porras, who were at the vanguard of environmental work in the third world approaches to international law in the TWAIL movement, which is a movement I've been part of since my early days in academia, and it continues to be very central to my work and to this collection and to Julia's work as well. So I was really fortunate at this time to also meet at the Institute for Global Law and Policy at Harvard Law School. I met Tyler McCreary, who's a legal geographer, and through him, Vanessa Lamb as well, who's a legal geographer. So this initial interdisciplinary group of scholars and practitioners published our research in a symposium in 2014 in the Leiden Journal under the very kind editorial guidance of Ingo, who was very encouraging in the early days. So it's really lovely to have this opportunity to get his thoughts today, many years later. And since then, Kishan and I had a very fortuitous meeting with Julia in Cairo, and the rest is history, as they say. So meeting a co-editor who's like-minded and who's committed to a project has been so serendipitous, because since then we sort of just encountered many more of our wonderful authors, and I think that's because Julia and I met. And so that's how the group sort of came together. And so Elaine Meyrand at Sherbrooke has been really key to taking this project forward, because she held meetings and symposiums at Sherbrooke and in Canadian law reviews. And then along with Kishan and Tyler, we also have Roger Marino, Kathleen Burrell, and the legendary Indigenous law scholar Irene Watson in the collection, who all speak to Indigenous legal traditions in diverse ways throughout the volume. And then we have the wonderful Kate Storr, Dana Scott, Adrian Smith, Tommaso Ferrando, and Irina Petrova, who were able to integrate insights not only from the different areas of law that they address, but also perspectives from very different continents and regions of the world into their analysis. So, and that was really crucial for us, because one theme that runs through all the chapters in the book is the inextricability of economic, social, and environmental concerns. And that's why I'm really happy that we're doing this launch at Sigel, because, every chapter talks about the relationship between the way we treat each other and the way we treat nature, and how those things are inextricable. And that there's this urgent need to democratize and decolonize international law, which remains not very international at all. And if we don't make space and lift up subaltern legal traditions from across the global south, and that includes, the south in the north, we won't find solutions to contemporary environmental and social challenges. So that's some of our broad aims and goals. I'm going to now hand over to Jules to explain our structure and methods. Thanks.
Great, thank you so much. And I want to also say a massive thank you to Ivana for organising this event, and to Devanshi, Saptarishi and Ingo for being part of this launch today. I'm really looking forward to the discussion. But I guess my biggest thanks and gratitude is to Usha for trusting me to bring me on board to be part of this project, and to sort of work together to bring it to fruition. And I do think over the, it's been a long process of sort of shepherding these various chapters to publication. But I do think that over that period, the audience for this book and for the arguments that we make in it and the way of thinking that we propose has actually grown. And I think there's more receptivity for the arguments being made than there might have been a decade ago, or even 2, 3, 4 years ago. I think it's increasingly becoming evident to all international lawyers that they cannot not engage with the questions of the ecological crisis. And I hope that what this book offers is a way of thinking about the ecological crisis and the questions of nature as structural part of how international law has organised our world, and not just some side thing that can be tinkered with, but that we do really need a fundamental transformation of all our core doctrines and tenets and ways of thinking international legal relations, if we are to address or to make the fundamental transformations that are necessary in this moment of climate crisis and biological extinction crisis as well. So I'll quickly talk through the structure of the book. The book is divided into 3 parts, each speaking to slightly different concerns. So part 1, which is entitled Locating Nature in International Law Towards New Thinking, contains 3 chapters that introduce the themes of the book, the questions being posed, their relevance, and the urgency of providing methodological tools for new thinking. So we hope that together these chapters will provide a critical and historical overview of international environmental law, and then explain also why we need to look beyond the parameters of this specialisation in order to understand the role of nature in international law. So putting forward the reasons for this project. And so that starts with a piece by Usha and Kishan that sets out the imperative behind the Locating Nature project. And then we have a wonderful piece by Helene Marad, who explains the history of international environmental law and talks about how it adopted rather than challenged the liberal idea of nature as a resource and a property, and sort of shows how this is sort of taken up in various different stages of environmental law and really becomes very pronounced in the neoliberal era. Then there's a chapter by myself where I try and grapple with some of the developments in contemporary environmental governance, particularly on the idea of the offset relationship, where I argue that the idea of the offset, that we can sort of make up for environmental harm in one place by doing environmental protection in another, brings together two different ways of relating to nature. And I try and understand both those histories of ideas of extraction and ideas of stewardship and the way they come together in a really problematic way in this offset relationship. So that's part one of the book. In part two, which is entitled Unmaking International Law, we have 6 chapters, and each of those consider a fundamental concept of international law. So free commerce in the first, sovereignty, jurisdiction, territory, human rights, and labour. And so each of these chapters, the authors have taken on board sort of a way of thinking about how that concept has constructed, shaped, and controlled the natural world, and how such constructions are linked to questions of environmental degradation, to resource allocation, and to environmental injustice. So we have a wonderful historical piece by Ileana Porras that looks at formative international law scholars, Victoria, Gentili, Grotius, and Vital, and looks at how nature didn't really appear in these writings until nature could become a commodity or an object of trade and property rights. Then we have a chapter by Tyler McCreely and Vanessa Lamb that explores contestations over sort of ideas about how sovereignty is produced through practices of resource governance, and they look at 2 case studies, challenges over a pipeline project in Canada, as well as a hydropower project on the Thailand-Myanmar border. And then we have a chapter from Karen Mikkelsen that looks at the idea of territory and looking at the classification of territory beyond the jurisdiction of states, as well as the idea of the common heritage of mankind. So those 3 chapters were all chapters that were revised slightly, but had been published previously in the Leiden Journal of International Law. And then they're complemented by some new additional chapters. So we have a wonderful piece by Kate Stahl that looks at the idea of territory and how this is a really Eurocentric construction of a particular relationship between community, authority, and place. And she asks really provocatively whether the concept, not just sort of, territory formally, can be decolonized. Then there's a chapter by Usha where she provides, I think, a really powerful and persuasive critique of human rights. So looking at how human rights normalize a series of false conceptions about our collective self and the detrimental social and ecological consequences this have. Adrian Smith and Dana Scott then conclude that part, and they examine sort of how this liberal mythology that separates labour from land structures how international law distributes social and environmental harms in particular ways. And so they're looking also at the continuities between the historical economy of extraction and how some of those same dynamics are being replicated in moves to the so-called green economy. And I think thereby really highlighting why we need to address those fundamental extractive relationships to avoid replicating them moving forward. And so then finally we have part 3, and that's entitled Alternatives and Remakings. And in that section, the authors try and suggest different ways of thinking, other epistemological tools or other traditions that we could draw on in trying to remake international law. So we have Daria Petrova and Tomasa Ferrando looking at the idea of commoning, and they talk about commoning as a verb rather than just the commons as a idea or a property relation, and talking about ways how the idea of commenting can contest the way in which international law encloses nature, knowledges, and time. And then we have a chapter by Keishan, again, who looks at broader ideas about narrative and myth making, and how they sort of found how we could contest the foundational myths of modernity through more ideas of pluralized value formation and the revalorization of eco-cosmologies. So taking a really quite a planetary approach and stepping away from what are the broader myths and perspectives, how could we reframe our current orientation? Roger Marino looks at the laws and politics of the rights of nature approach and traces some of those tensions and contradictions in what happens when we incorporate ideas of rights of nature that might derive from Indigenous cosmologies within Western legality. We then have Kathleen Birrell, who is really influenced by literary studies and law and the humanities approaches, looking at sort of global imaginaries of nature and climate change and the Anthropocene, and how these can be contested through other counter narratives, drawing there on the literary work of Indigenous author Alexis Wright. And then finally, Irene Watson, I think, really powerfully concludes the collection by looking at how really the seeds of the global failure to live relationally with the earth are embedded in colonialism, and how this is the source of so many of the problems that structure our relationship with the earth. And again, arguing that the only way forward is decolonisation and the need to recognise Indigenous law as law and to learn from it in order to better collectively care for our world. And so we hope that those parts sort of set out, firstly, why we need to rethink, to think about, you know, these core concepts of international law and sort of unpack them, and then to offer tools about how we could think differently. And again, I think particularly part 3, I think there's so much scope for expansion there, drawing on further ideas, further possibilities of radical rethinking. And similarly, I think we flag in the conclusion of the essay that I think there's a lot more work that needs to be done unpacking key concepts of international law. So the idea of the person, or, you know, the refugee or the investor, these various figures, the idea of, you know, knowledge as commodity, the idea of migration, various, I'm blanking now on some of them, but we suggest there are still so many other concepts of international law that I think require this sort of investigation. And so this project, in a way, is, you know, the beginning of this type of inquiry, but that we hope that the approaches and methodological tools we present sort of inspire others to sort of take up some of this work, both of unpacking existing concepts of international law in order to allow for rethinking, or that work of drawing from other approaches to rethink our relationship to the natural world and to law. Thank you.
Thank you, Usha and Julia. Now I will move on to Ingo, who will say a few words about the first part that Julia, of the book that Julia just introduced. Ingo?
Yes. Thanks so much for having me, and for well, first of all, bringing together this wonderful book, so rich of insight, and inviting to think along, think further. So in hindsight, we were already in 2013-14 interacting in the context of the symposium in the Leiden Journal of International Law. We felt incredibly lucky that you brought your work to our attention, and now in hindsight we feel even more lucky to see what has happened with that work and how it has developed even further. So this is really wonderful. So I think, you know, there's so much entirely accurate, sober analysis that is entirely compelling and eye-opening in parts. So I think it's spot on to say that international lawyers have not yet provided solutions, that they are in so many ways entangled in problems of many dimensions in the present, that this view of the problems is often glossed over also by the compartmentalization, by the fragmentation. The problem always seems to lie somewhere else, not only in a different regime. If we're an environmental lawyer, or if we're a human rights lawyer, it's with the trade law. If we're a trade lawyer, it's with the human rights law. So all this, even if in many ways, especially among a relatively critical crowd, you might say it's a given, it's obvious, of course, law is part of the problem. And even if we agree on that immediately in principle, in practice, it always gets lost again. And a lot continues to go wrong in that regard. What I also like is that you extend that analysis to international lawyers as such, that oftentimes carry over responsibility to politicians, right? So it's not us, politics has to get it done. Okay, fine. So a lot of things work incredibly well in the volume and specific insight, and also the general aim of understanding the natural world and relation to it, and how that has underpinned organized the international legal order has been missing, and you really fill a gap, identifying, unpacking, reworking the assumptions that we have embedded in international law, that we have as international lawyers about the natural world. So that's spot on, and I really appreciate also the take, which I share, that a lot of the current predicaments can only be tackled if we think the relationship to nature simultaneously together with how we relate to one another, and that the emancipation would also be simultaneous in that regard. Again, there's a lot of specific insights. I try to draw out some as I go along, but generally the comment is, my first and foremost most important comment is, if you haven't read it, read it. I do have two points that I would want to think through further together with you. One is about the dynamics that stabilize the assumptions, and the other one is about the West and its thinking. So stabilizing the assumptions, yes, there's a co-constitution of the relationship with nature, and there are many different dynamics. There's patterns of knowledge. There's not only the lack of knowledge about how we relate to nature, but also deeper ways of stabilizing assumptions in forms of rationality that order and counts that orders and determines what counts as knowledge in the first place. So you have Kathleen Burrell's chapter later. I know it's not part of part one, that starts with Amitav Ghosh and the quote that the climate crisis is also a crisis of culture and thus of the imagination. Adorno said something similar, that whatever differs from the existent will strike the existent as witchcraft. So you have these really, really deep assumptions that are part of the forms of rationality and ways of thinking. My point here would be that I think, and you do draw attention to that, but that is something that I would want to perhaps draw out further, is the conditions of being, the materiality of these systems of knowledge and forms of rationality that further stabilize the assumptions of how we relate to nature. And that includes being separated from nature in so many ways through modes of thought, but also really quite physically, right? And what is doing that separation? So you write in the introduction that we are trapped in seemingly inescapable orbit of global capitalism. I think that gets close to it, or right to it. Alain Maran's chapter then speaks on the patterns of neoliberalism and demands for the optimal allocation of resources. Yulia goes on in her chapter on the green economy to speak about the economic ordering of what she terms the quote offset relation, the combination of extractive and productive power. over nature. And I think that is all it's really, really well done and productive. I just thought that in the whole of the chapters, I thought that the role of capitalism and modes of ordering in determining what is realistic and unthinkable, and what exes on in continuing to subjugate nature could here and there perhaps have been brought out still further. But you go in that direction many times, and it's really just a small remark and impression of reading almost. Because I think it also relates to how we are distanced from nature, from sickness, from illness that is confined to hospitals, that many people would feel eerie to visit because we would be confronted with our mortality, to the distancing from suffering of other non-human animals that we don't see. It's confined to slaughterhouses, systems of mass murder, and that also dynamics that prevent us from seeing ourselves as animals, as mortal animals. So we never see each other as ourselves as food in the eyes of others. You have this short, nice essay by the feminist Val Plumwood, In the Eye of the Crocodile, on her experience of understanding that she is seen as food. So these kind of things are prevented. And my thoughts here, which leads me to my second point, my thoughts here build on a couple of my own private heroes of critical theory. And that is, my private heroes of Max Horkheimer and Adorno. Because for them, the separation of animal suffering, human and non-human, was at the core of social pathologies. So it's the negation of massacre that enabled unconstrained violence for them. So here the simultaneity of thinking our relation to nature and our relation to one another was really already at the core of their thoughts. So Horkheimer writes that in the Critique of Instrumental Reason, Adorno in the Negative Dialectics, Western culture is based on mass murder, which of course he cannot accept. So for Adorno, there's this nice quote, it abhors Western culture, stench because it stinks, because as Brecht put it in a magnificent line, its mansion is built on dog shit, end of quote. And you have a lot of philosophy that reacts to that and takes that thought further, including the animal ethics of Derrida, l'animal que donc je suis, the animal that therefore I am, philosophies of the corporality, of bodily existence. And all of this, like Derrida's animal turn, so to speak, was just like for Horkheimer and Adorno, much more than an animal ethics. It was ultimately a philosophy, I would say, of social emancipation. And others have thought along similar lines. The French philosopher Corinne Pélochon has done that, drawing out this genealogy of thought in her book, Enlightened in the Age of the Living. So this goes to, I do this to suggest that I find the categories of a global north and the global south very strong as categories of lived experiences and comparable predicaments, that thinking through that relation of domination, of hegemony embedded in knowledge continues to be incredibly powerful. I buy into analysis of epistemicide and so on and so forth. Where I would want to caution a moment would be reification of West and Western thoughts, limiting also philosophy that originates in the West to confines, quote, of Western modernity, and to draw attention also to different traditions originating in the West, not to vindicate thought originating in the West. So that's not the point, but that just because these scholars also have useful things to say, and I don't think that the origin of an idea is a good indicator about how useful it is. So that not only holds for the West, but it would also say for much of the non-West, or also for much of indigenous and marginalized knowledge, I would say. So of course it's not itself emancipatory, and you don't say that. I haven't heard anybody say that recently, but that the origin of that indigenous knowledge doesn't mean that it's progressive or just or otherwise good, only because it's been subdued or marginalized. And for me, the traditions of critical theory that I sketched continue to be an important source of insight, a mode of thinking, an ethos that I just consider to still be helpful. So to conclude, it's a wonderful project. My great compliments on this wonderful, marvelous work. Everybody, that's the most important comment. Do read the chapters. And the 2 points to perhaps draw it further and continue to discuss relate to first the materiality, the conditions of being that stabilize the assumptions of how we relate to nature and to each other. And then second, to perhaps consider alliances with critical thought that has also originated in the West, not because the West should have anything to say on the topic, nor because you should have built your argument that way rather than another way. That's not my point, but just to say that you have other allies to think simultaneously how to change the way we relate to nature and how we relate to one another, because that has already been a very strong point, perhaps the point in a critical theory and in a dialectic of enlightenment. Thank you so much.
Thanks so much, Ingo. Saptarishi.
Yes, hello. Here we are at this ungodly hour of now 7:38 a.m. Usha, Julia, this book wasn't so excellent, and I wasn't able to wave it in front of a screen like this. There'd be almost no reason to get up. Thanks very much for having me here. So I'm at the tail end of a super bug highway, so my throat will collapse from time to time. I apologize for this. So I'm going to read part of my remarks just to make sure I stay on time. So first and foremost, I'm very grateful to Ivana, Professor Isailovic, for inviting me to be part of this panel, and of course to Usha and Julia and the authors for the long-awaited joy of reading this book. It's hard to do the rigor and complexity of the work due justice without hugging each of you in person, but here's a small, modest try. The existence and experience of reality, by which I mean the character of natural forces, the scope and scale of social expectations, the establishment and maintenance of political authority, of law and order, of justice, but also the establishment and maintenance of chaos, cannot be distinguished from our uses of the world. International law as a modern expertise has historically been established on denying this experience, this premise. International lawyers are like gardeners, like all modern lawyers and scientists who become gardeners by virtue of their ability to enter and exit the garden and change it in this course. International lawyers are specialized in a particular sense in that they pretend in part that anything that looks like gardening is in fact just harmonization. This is international lawmaking in the traditional mindset. And to the extent that you were hoping to unscare those people, I don't think you're going to succeed, but I'm going to let you respond to that. Trail has criticized this mindset, but Trail has for too long neglected science, technology, and nature. While many senior Trail scholars, many of whom are cited in this volume, have looked at race, the economy, colonialism, and even space, they haven't looked at the environment and they haven't looked at science. One of the most important achievements of this collection is its unrelenting dedication to showing how stuff comes to be. That is the work that goes into creating an ontology of reality, including the effort it takes to pretend that no one's at work and that stuff just happens or stuff just is. And it's fantastic that this is a collected volume, because this totality cannot be grasped by any individual, no matter how great or white or male. And it would be grating if there was such a person who attempted this. Nature in this volume is international law's non-disposable fiction. It cannot be denied, nor can it be grasped in its totality. But efforts to sketch its shape and limits are in fact, as the authors unanimously show, are in fact sketches of the shape and limits of legal, political, social, and economic power. This watercolor project, as it were, happens in Ileana Porres's account by people who believe that they are serving divine code itself by facilitating trade and travel to harmonize scarcity at home with plenty abroad. It happens in Tyler McCreary and Vanessa Lamb's study quite literally as people who we might not think are working for the state draw representations of where territory is and is not going to be affected by a dam that is being imagined as a means of energy production in a transition between democracy and dictatorship. In Kate Storr's analysis, this drawing is done in the language of law as experts conflate territory with sovereignty and jurisdiction, that is, with legal and political authority over abstract neutral space, not ground, not the dirty earth, rendering territory partially unsalvageable as a promoter of actual decolonization or global environmental action. It happens in Karen Mickelson's chapter by a strange, often unspoken intergenerational agreement that the spaces which no one owns or which no one can clearly claim are nevertheless there to serve humanity, and therefore in some way must be organized and divvied up for productive stewardship by someone. In Adrian Smith and Dana Scott's scholarship on solar photovoltaic tech installation debates in Ontario, the precarity of labor is absent from narratives both for and against the adoption of renewables tech, based on non-agricultural uses of land arguments and the old right to landscape NIMBYism. And here too, each set of claims is in effect a claim to priority and authority over the land, the landscape, and a wholesome vision of the country itself. I'm very grateful to be invited to speak here because every bit of what I read is deeply related to my own work on disasters, and in the future, the relationship between conflict disasters and human displacement. Disaster imaginaries are everywhere in this volume. The alleviation of scarcity in Porus, the pictorial designation of no loss and damage in McCreary and Lamb, the historical and conceptual impossibility of territorializing and decolonizing in Storr, the trepidation that non-stewardship and productive use will make resource destruction inevitable in Mickelson, the fear and longing for safety and for safe energy and a return to a country full of lovely little hamlets and family farms in Smith and Scott. Disaster imaginaries are at the center of this book because disaster imaginaries are at the heart of international law and multilateralism. But for too long, they've been ignored in looking at environmental law and the relationship between international law and nature. From sanitary conferences that ran from the mid-19th century, the end of the Second World War, to the early 20th century laws regarding the protection of victims of war, but also efforts to distinguish these victims from the victims of natural disasters, to mid-century emergence of environmentalism and international environmental law as a balm against the excesses of World War II prosperity, to the late 20th century emergence of such a magical thing as laws related to disaster. International lawmaking is an exercise in trying to solve the problem of nature, an exercise that has continually subjected people to the resulting solutions. So we are continuously and self-righteously imposing one and exchanging one vision of determinism for another. My own work has attempted to show how idealized visions of the nature-society relationship has produced both disasters and modern states during the 18th century and the present. And two new projects will try to extend this relationship into studying the relationship between conflict, disaster, and displacement between 1850 and the present. Part of this will involve rethinking a little, along the lines that Usha and Julia and their co-authors have, the emergence and legacy of environmentalism, which is basically a dead word now, and studying the ongoing efforts at international lawmaking, for instance, in the international law draft articles on the protection of persons in the event of disasters, and on environmental protection during armed conflict, both which are being considered by the General Assembly and have been drafted, with due respect, in my mind, without enough thought to environmental history and disaster studies, areas in which I work. Finally, underlying my thinking on these three lines of research is a core commitment that is underscored in Usha Natarajan's chapter on who and where we are. For my money, human rights proponents have long knowingly missed the point when they prioritize the ICCPR as the norm and the ICASCR as the kind of stepchild consolation. International human rights is not a failure in and of itself, but its failures are frequently tied to the inability to ground civil and political rights in economic, social, cultural, and economic realities. The law's failure to even conceive of environmental refugees reflects this deep deficiency. Finally, in a metaphysical sense, I've long believed that humans who can, as a species, organize waste and cruelty towards nature and non-humans are capable of and will do almost anything to each other for reasons that may not be good, but under real-world stresses will be found to be good enough. Climate change and the conflicts that are arising because of it and will only escalate will create more and more of these good enough reasons. There is therefore an extremely urgent, and a almost stifling need to talk about these things as if they are real things. And international law has failed to talk about nature as a real thing and about humans' relationship with nature as a real thing that matters, that affects experts and their lived expertise. This book is such a joy to behold, and it's so painful to read without making notes on every single inch of the margin space. I've failed to do that. I'm very glad to see the editors and the authors, and very glad for the authors and the editors for producing it, and to Ivana and her colleagues for having me here to gush about it in my croaky little voice. If I have a question for Julia, Usha, and their co-authors, it's this. This will be I and some of the people who I see on this on the Zoom meeting have already waved this book at each other in classes and in visiting and in guest lectures that we delivered for each other. You have an enormous fan following / people who think this thing and have wanted to write about this thing, and for whom this book is armament. There is a generation and multiple generations of students for whom this book, I hope, will become required reading, or at least in my case, just, here, read this, non-required, but definitely read this, summer reading, right? My question is, but there's also an older generation of international law scholars who are sympathetic to this, but still don't integrate this kind of thinking into their writing. And so my question is twofold. First, what do you think, and how do you go about responding to scholars who've been writing about this stuff for a long time, but in whose work and in whose organizing, whether it's in conferences and workshops, nature and the environment are still missing? And second, how do you respond to people who know something about this and know that this distinction, this separation of nature, this keeping out of nature, this ruling over nature, this governing nature is core to their expertise, but who will obviously find it almost an existential crisis to therefore give that up, right? So how do you see the relationship between educating them in this beautiful and just lucidly, deeply researched book, and the heart palpitations that they're going to encounter when they start recognizing themselves as doing the work you're accusing them of doing? These are extremely important and difficult questions, which is why I'm extremely glad not to be in this volume. So thank you very much for this opportunity to speak about the book, and I'm very, very grateful to be here and to have read it. Thanks very much.
Amazing. Thanks so much, Saptarishi. Devanshi.
Yeah.
Your turn.
Thank you so much, Ivana, for inviting me to comment on this. It was a no-brainer for me to take up the opportunity to read this work by Usha and Julia, having met Usha this year at the SGL summer school that you organized, and having read the work of Julia and heard her online a couple of times. And I'm also very happy to hear the comments from Ingo and Saptarishi, and a bit scared to follow them. In my comments, I'm going to do two things. Firstly, I'll show how the themes in the book resonate and connect to my own thesis. And it can also inspire further ideas. So there's going to be lots of referencing from this book, definitely. And also, secondly, highlighting some of the themes from each of the chapters in part 3 that resonated with me. The topic of my PhD thesis is Geographical Indications and Sustainable Development, Preparing GIs for the Future. And I'm following a critical decolonial approach to this topic, trying to uncover coloniality in geographical indications law and highlighting the power fields that give shape to how the law looks today, and the rush to commodify culture and nature without deeper thinking on negative externalities or on the agency of the most vulnerable actors involved in the supply chain. So I already see links to how to do this and further discussions on this in part 3 of the book. I'm also taking a critical approach towards the concept of sustainable development. And one of the criticisms that I trace already in the state of the art is the presumed universality of sustainable development for international law, even though there is a pluriverse of more sustainable ideologies that are biocentric. I also argue that GI law is not sufficient in itself to carry the burden of sustainable development and needs to borrow and may need to borrow from other fields, concretely from international environmental law and international human rights law. However, the problems with these two fields of laws are also becoming slowly clearer to me the more I read. International environmental law has been constructed in a way that makes it easy to instrumentalize law to permit an unsustainable and extractivist relationship with nature. And again, this is something that we see and understand more clearly if I read the book. So people should think about this as an attraction to read the book. Same with international human rights law, how it has cultivated an unjust relationship with the Aboriginal peoples. That's the last chapter, the last essay in the book also gives further insights into this. The arguments in part 3 of the book are helpful in understanding these problems with the international law and also the colonialities and tracing the colonialities within international law of knowledge, of power, of the mind and the being. I'm going to now go into some important themes that I picked up from each of the chapters. Chapter 10 by Darina Petrova and Tommaso Ferrando shows how the law has been instrumentalized to universalize and embolden the culture-nature divide. The authors develop the concept of disecology to argue that what is needed is much more than using law to internalize externalities. They propose commoning of international law as an alternative. Chapter 11 by Kishan Khode shows how development myths have promoted an anthropocentric view of nature and traces the influence of looking outwards. Yeah, the influence of looking outwards, cosmos, space, and so on, and also of looking inwards of history, culture, biocentric views on the making of international law. And the author proposes a distributive theory of agency that would include both the human and the non-human. Chapter 12 by Roger Merino explains the right to nature in 4 waves and proposes an institutional architecture of the right from below, a different kind of governance and plurinationality that is shared sovereignty with indigenous nations to prevent appropriation of nature's voice. Chapter 13 by Kathleen Birrell argues that there is power in counter-narratives of rights and in literary interventions into global climate imaginaries. Here, there is also an important critique of sustainable development, and I quote, "The degraded political subject re-articulated as a neoliberal subject enmeshed in the perpetual struggle to accommodate itself to the world. It is insightful for me here that there are conditionalities to institutional acceptance of traditional knowledge, a need for performance before the gatekeepers of institutions accept an alternative narrative." This also connects to chapter 14 by Irene Watson, where the myth of terra nullius is being talked about, a myth that, I quote, "fitted with European paradigms of progress," unquote. The author proposes horizontal dialogue between colonialist interests and First Nations-centered epistemologies, which for me also shows a connection to decolonial methodologies such as listening and dialogue of wisdom that I'm engaging with in my thesis. For further thoughts, for discussion, I think to be able to arrive at alternatives and solutions, the exercise that the authors of the essays go through is to trace how the law engages with nature and acknowledges being aware of the power structures as well as the colonialities. And they in fact continue to do so when they're thinking of alternatives, such as green growth, Green Deal, so that in the search for alternatives, we do not reproduce the same problems. And we think critically about what can be reclaimed, what should definitely be buried, and where do we need innovation. While reading the essays in the third part, I was also thinking of practical examples. At the same time, very much aware that these cannot be prescriptive, and they have to always depend on a certain context. So yeah, if I had some questions, I would think of some more examples of commoning international law from different fields, and I know they will always depend on the context. So it's a challenge to be able to do that. But yeah, if I had to think of some questions right away, that's something that I was thinking of. Thank you very much for giving me the opportunity to comment, and I look forward to the discussion.